Hello, I am Dr. Rajshree Chatterjee, Associate Professor, Department of Journalism and Mass Communication, Jagannath University, Jaipur.
Hello everyone. Today I am going to discuss Contempt of Court Act 1971. The word contempt of court is a generic term that describes behavior in connection to specific proceedings in a court of law that tries to undermine the system or prevents citizens from using it to settle their problems. In exercising the exceptional jurisdiction which combines the role of judges and prosecutors, the court normally exercises restraint and applies the jurisdiction to protect the supremacy of law. Though judges as persons and courts and institutions of require no more security than the average citizen or institution. When the basic supremacy of the law is called into question, they require particular protection. Attorneys are frontline protectors of Indian Constitution and above all else require legal protection as whistleblowers. A contempt of court is intended to safeguard the system and prevent interference with the administration of justice. Undermining the grandeur of the system or the authority placed on judges is a significant concern. Crossing the line from valid criticism of a judgment into a completely new realm. Reasonable criticism of ruling is permitted, but a line must be drawn when it becomes abusive, irrational, baseless, accusation on judges, undermining the institution's basic legitimacy. It is difficult to determine the type of interference that warrants the judge exercising the exceptional power. Should all types of interference be considered contemptuous or just keen interference? It gets more difficult when we confront indirect influence, such as scorn via publishing. To understand it in detail, let's take a quick review about the brief history of contempt of court. The origins of contempt of court in India can be linked back to English law. Although India has evolved this idea and can be traced back in time. In England, Supreme Courts of record have long had the authority to penalize those who scandalize the courts or judges. This right was initially recognized by the Privy Council's Judicial Committee, which noted that offence of contempt of court and authority of Indian High Courts to penalize it are identical to those of the English Supreme Court. The first Indian statute on the law of contempt, the Contempt of Court Act, was passed in 1926, and it has since been amended numerous times to become Contempt of Court Act 1971. Defining the contempt of court, it requires the act of hostility, disobedience, or disruption of a court's orderly procedure is known as contempt of court. As an illustration, consider disrupting court's proceedings intervening with efforts to gather evidence, destroying evidence, defying a court order, and threatening witnesses. A contempt order may address conduct inside and outside of the courtroom, including open disrespect for the court. In other words, if you behave in a way that is upsetting, disrespectful, or compromises the integrity of the decision or result of a case, you run the possibility of being found in contempt of court. There are basically two types of contempt: being respectful to legal authorities in the courtroom, willfully failing to obey a court order. It also says that scandalizing the court itself, abusing parties who are concerned in the cause in the presence of court, prejudicing the public before the cause is heard. When a court determines that a certain action amount to contempt of court, it may issue an order known as being found or held in contempt, which during a court trial or hearing deems a person or organization to have disobeyed or shown disrespect for the court's authority. The judge's ability to punish behavior that interferes with the regular course of the court is his or her strongest authority. Injunctions and other equitable remedies are frequently enforced through contempt actions. In certain jurisdictions, refusing to comply with a subpoena, testify, fulfill your jury duty, or provide particular information can be considered as contempt of court. If we talk about the punishment, a person may be found to be in contempt of court if they disobey a valid court order, disrespect the judge, interrupt the proceedings with unruly behavior, or publish or withhold information that is thought to undermine the integrity of the legal process. Contempt of court is a process crime because a judge may sentence a person found guilty to penalties like a fine or jail time. Both the High Courts and Supreme Court of India have the authority to impose penalties for court contempt. Contempt of court is punishable by simple imprisonment for a term up to 6 years, a fine up to 2,000 rupees, or by both. According to Section 12 of the 1971 Contempt of Court Act of the IPC, the following are the remedies of punishable order. The Contempt of Court Act 1971 has been amended in 2006 as well to include Section 13. The 2006 Contempt Act may be in the name of new law. According to this section, there are specific situations or cases in which contempt of court can be penalized. No court subject to this act will impose penalties for contempt of court unless it has been satisfied that the contempt has such a serious nature that is considerably interferes or tend to substantially interfere with the due administration of justice. According to the Clause A of Section 13 of this Amendment Act, it also stipulates that the court may grant the defense of justification of truth if it determines that the act was done in the public interest and the desire to invoke the defense is genuine. Now, let's go ahead with the other points. However, in India, the contempt of court is of two types. The two categories are as follows. Civil contempt. It often involves the failure of someone to comply with a court order. Judges use civil contempt sanctions to coerce such a person into complying with a court order the person has violated. Criminal contempt. The charges are punitive, meaning they serve to deter future acts of contempt by punishing the offender no matter what happens in the underlying proceedings. Criminal contempt has been defined as the publication, whether by words spoken or written, or by signs or by visible representation, or otherwise, of any matter or the doing of the other act whatsoever which scandalizes or tend to scandalizes, lowers or tend to lower the authority of the court, prejudices or interferes or tend to interfere with the due course of any judicial proceedings, interferes or tend to interfere with or obstruct or tend to obstruct the administration of justice in any manner. High Court means the High Court for a state or a union territory that includes the court of the judicial commissioner in any union territory. High Court means the High Court for a state or a union territory and includes the court of the judicial commissioner in any union territory. It is very important to note that contempt of court refers to the offense of showing disrespect to the dignity or authority of a court. The objective for contempt is stated to be safeguard the interest of the public if the authority of the court is disintegrated and public confidence in the administration of justice is weakened or eroded. The Supreme Court and High Courts derive their contempt powers from the Constitution. The Contempt of Court Act 1971 outlines the procedure in relation to investigation and punishment for contempt. The Act divides contempt into civil and criminal, and that we have already discussed. Now, here are certain arguments against contempt of court. Against civil liberties, wide scope of contempt, and international disuse of contempt doctrine. A law for criminal contempt gets in conflict with India's democratic system, which recognizes freedom of speech and expression as a fundamental right. In this manner, the judiciary draws resemblance with the executive in using laws for a chilling effect on freedom of speech. The definition of criminal contempt in India is extremely wide and can be easily evoked. Also, suo motu powers of the court to initiate such proceedings only serve to complicate matters. Already contempt has practically become obsolete in foreign democracies and jurisdiction recognizing that it is an archaic law. The arguments that are in favor of contempt of court are high number of contempt cases. There still exists a high number of civil and criminal contempt cases pending in various high courts and supreme courts. A affecting judiciary's reputation. Amendment in the definition of contempt may reduce the overall impact of the law and lessen the respect that people have for court and their authority and functioning. Constitutional source of contempt power. Supreme Court and High Courts derive their contempt powers from the Constitution. This Act only outlines the procedure in relation to investigation and punishment for contempt. Impact on subordinate courts. The Constitution allows superior courts to punish for their contempt. The Contempt of Court Act additionally allows the High Court to punish for the contempt of subordinate courts. Adequate safeguards. The Commission noted that there are several safeguards built into the Act to protect against its misuse. The concept of punishment we have already discussed. Now let's discuss the defenses. A person charged with civil contempt of court can take the following defenses, like no knowledge of order, disobedience or breach was not willful, order disobeyed is vague and ambiguous, order involved more than one reasonable interpretation, compliance of the order is impossible, the order has been passed without jurisdiction. Defenses against criminal contempt are innocent publication and distribution of matter, fair and accurate report of judicial proceedings, fair criticism of judicial act, bona fide complaint against the presiding officer of a subordinate court, no substantial interference with the due course of justice, justification by truth, the statement complained of is open to different interpretations, and defamation of the judge personally. There are certain remedies against the order of punishment. Number one is apology, and second is appeal. The contemner may use apology to the court, and the court may remit the punishment awarded for the contempt if the court is satisfied that the apology has been made with real sense of repentance. In appeal, according to this Contempt of Court Act 1971, it has provided for the statutory right of appeal against the orders of High Court passed in the exercise of its jurisdiction to punish for the contempt of court. What are the necessary ingredients to constitute contempt of court in India? Is interference with administration of justice, where the Supreme Court has held that in order to constitute the offence of contempt of court, it was not necessary to specifically prove that an actual interference with administration of justice has been committed. In scandalizing the court observed that in a free marketplace of ideas and criticism about judicial system or judges should be welcomed. So as long as criticism do not impair or hamper the administration of justice, this will not consider as scandalizing the court. It is very important to note that the court will also have to consider the degree of harm caused by affecting administration of justice. If it is slight and beneath notice, then the court will not punish for contempt. Lastly, let's discuss one case for the reference. In Pritam Lal versus High Court of Madhya Pradesh, the Supreme Court held that to preserve the proceedings of the court from interference and to keep the streams of justice pure, it becomes the duty of the court to punish the contemner in order to preserve its dignity. You can also see the following cases for your reference. Lastly, I would like to say that anything that curtails or impairs the freedom of limits of the judicial proceedings, any conduct that intends to bring the authority and administration of law into disrespect or disregard, or to interfere with or prejudice parties or their witnesses during litigations. Consisting of words spoken or written which obstruct or tend to obstruct the administration of justice. Publishing words which tend to bring the administration of justice into contempt. A fair trial or any cause or matter which is subject to civil or criminal proceeding in a way to obstruct the cause of justice. An apology shall not be rejected merely on the ground that it is qualified or conditional if the accused makes it bona fidely. Lastly, I would like to say thanks that the following are the information that are very important for a media student to know so that he or she does not fall under the category of contempt of court. Thank you so much.
क्रॉस कर दो इसे.